I'm Rob Deutschmann, and I've been serving personal injury victims for over 20 years. After a statement of claim is issued and a statement of defense is received, the next step in the litigation process is to arrange for an examination for discovery. The examination for discovery provides an opportunity for lawyers to ask questions of the other party. For the plaintiff's lawyer, it's an opportunity to ask the defendant details about the accident, including things like what the defendant was doing that day, the defendant's health that day, the condition of the defendant's vehicle. The plaintiff's lawyer is trying to determine what actions were taken by the defendant that resulted in the accident causing damages. The plaintiff's lawyer is trying to assess the extent of the defendant's negligence and the defendant's liability. For the defendant's lawyer, the insurance company's lawyer, it is to ask the plaintiff a wide range of questions. These questions will cover things like your pre- and post-accident medical condition, the injuries suffered in the accident, the status of those injuries, treatments that you have received, medications that you are on, the prognosis for your injuries, the impact of the injuries on your activities of daily living, including housekeeping and home maintenance, recreational activities, and of course your ability to work and other work options. The defendant's lawyer is trying to determine the extent of the damages that they could be facing in this claim. During the examination, we will undertake or agree to provide the defense lawyer with additional documentation, including things like medical records and income tax returns. These are called undertakings. These documents will be provided in the months following the discovery. We will have provided the defense lawyer with a lot of information before the discovery, with details about your medical condition and appointments, your employment, income, and other relevant information. You are there to answer to the best of your knowledge. If you're not sure, it is okay to say, "I'm not sure, but I think," and then give an answer. But remember, if you don't know the answer to a question, then just say, "I don't know." Not every question requires an answer. I tell my clients that a discovery is the easiest test you'll ever take. You only need to answer what you know. You are not expected to know exact dates for various appointments and treatments and what happened at those appointments. The opposing lawyer will have a lot of that information already. The primary purpose of the discovery is to provide the opposing lawyer with an opportunity to assess what type of witness you will be. What type of person are you? Do you come across as forthright and honest, or someone that is embellishing? It allows them to put a face to the person they've been reading about. The lawyer is assessing how you will be as a witness at trial. Will the judge or jury like you? A likable witness has strong credibility. Your credibility is key when you are describing your injuries and how your injuries affect your ability to function. The discovery is usually held in a small boardroom. You are in the room with your lawyer, the lawyer for the insurance company, who is acting for the defendant, and a court reporter. The opposing party or defendant will not be there. Before the discovery starts, you will swear or affirm to tell the truth. The discovery is similar to providing evidence under oath in a trial. The discovery is tape recorded because the court reporter may be required to prepare a transcript of your testimony at a future date. A transcript is usually prepared if your matter proceeds to trial. Because the discovery is tape recorded, you should be mindful of a few things. You should wait for the full question from the lawyer. This will ensure there is no over-talking on the tape and make it easier for the court reporter to prepare the transcript. It will also make sure that you hear the entire question before answering. Finally, it can be annoying to the person asking the question if the person answering is always jumping in to give an answer before the full question is asked. If a question only requires a yes or no answer, then you must say yes or no. Sometimes we will only nod or shake our head, and that cannot be picked up on the tape recording, so you will be asked to state yes or no. If you're pointing to a body part to indicate where your injury is or your pain is located, you must say the body part and what side of your body, like left shoulder or lower back, rather than just here and there. You can dress in comfortable attire. The discovery will usually last 2 to 3 hours, although it can go longer. You can take a break at any time. If you need to have a bathroom break, or if you want to go for a walk, just ask and the other side will oblige your request. If you need to stretch, another option is to just stand while you answer questions. The microphone will still be able to pick up your answer and the discovery will not have to be interrupted. Remember, though, that for the whole time of the discovery, you are under oath and your lawyer cannot review your discovery with you during any breaks before your discovery is completed. Answer questions to the best of your ability, be honest and forthright, Do your best to answer questions as completely as you can, and your discovery will be successful. I'm Rob Deutschmann, and I've been serving personal injury victims for over 20 years. Our personal injury team is committed to ensuring you receive full compensation for your injuries. We are committed to your future.